Welcome to the Real News Network. I'm Kim Brown in Baltimore. The federal government has systematically spied upon Yahoo email accounts, according to a Reuters story that was published on Tuesday. The story relies on several former employees who say that Yahoo agreed to install spy software on their servers to search all incoming and outgoing emails for certain keywords or phrases. Furthermore, Reuters reports that Yahoo's chief security officer, Alex Stamos, decided to leave Yahoo in protest over the company's agreement to comply with the government in this matter. Security experts say that such government surveillance of email accounts is far more sweeping than we know. And joining us to discuss this latest Yahoo email scandal is Ashley Gorski. She is a staff attorney at the ACLU's National Security Project, where she works on issues related to electronic surveillance, national security, prosecutions, and detentions at Guantanamo Bay. Ashley, thank you so much for joining us here on The Real News.
Thank you so much for having me, Kim.
Ashley, the Reuters reports, which Yahoo has now partially and carefully denied, saying that it currently does not have spy software on its servers, leaves many questions unanswered. Based on what you know from this story, and assuming that it's true, how serious would you say that the government spying on Yahoo email accounts is?
Well, Kim, assuming that the facts reported in the story are accurate, it appears that the order that was served on Yahoo is unprecedented. The government, according to the Reuters report, essentially ordered that Yahoo conduct a general search of all of its customers' incoming emails in order to locate information that was specifically of interest to the FBI or the NSA. And this is really reflective of a new surveillance paradigm in which the government is constantly scanning our communications for keywords or key terms that are of interest to it.
So other companies that provide email services, such as Apple, Microsoft, and Google, have issued statements saying that they did not receive such a sweeping government request, and that if they had, they would have challenged it in court. And apparently Yahoo did not. Could Yahoo have challenged it, and would it have been able to stop the request if it had?
We believe, based on the reporting, and admittedly the details are sketchy, but it does appear that Yahoo could have challenged this order in court. Whether it would have been successful is harder to say, but it is deeply disappointing that Yahoo simply chose to comply with such a sweeping surveillance order that plainly violated the Fourth Amendment. And in a post-Snowden world, customers are relying on tech companies more than ever to stand up to these novel spying demands in court, in large part because the customers themselves have no opportunity to challenge the spying in a judicial forum. There are many legal doctrines that serve as barriers to individuals who are concerned about the surveillance of their communications to challenge that surveillance in a civil court.
But doesn't U.S. law, including the Foreign Intelligence Surveillance Act, or FISA, state that such surveillance requests have to be approved by the FISA court? Could it be that the FISA court would not have approved such a blanket surveillance request?
So it's still hard to say exactly which authority this order was issued pursuant to. Right now, most of the speculation points toward an authority known as Section 702, and this is a portion of a law called the Foreign Intelligence Surveillance Act Amendments Act that was enacted in 2008. And under Section 702 of the FAA, the government just goes to this secret surveillance court, which is known as the Foreign Intelligence Surveillance Court, and gets an order on an annual basis that allows it to target any non-U.S. person located abroad who's reasonably likely to communicate what's known as foreign intelligence information. And that standard is defined extremely broadly to encompass even basic information that relates to the foreign affairs of the United States. So if this surveillance took place pursuant to Section 702, the Foreign Intelligence Surveillance Court did not individually necessarily approve this surveillance or the targets of this surveillance. What the surveillance court may have done was issue at a very high, general, abstract level an authorization for this kind of surveillance to occur, but it wasn't looking at the particular targets of the surveillance. And it's unknown whether the court specifically evaluated the lawfulness of Yahoo conducting this kind of search on its own.
And that's been a lot of the complaints of privacy advocates, is that the FISA courts, what happens within the FISA courts are not disclosed to the public. So there's no way of independently verifying what is actually being requested and whether or not it's legal or constitutional in that way. But if the FISA court approved it, what does this mean for privacy in the United States? Has the Fourth Amendment, which is supposed to protect one's privacy from arbitrary government searches, has that effectively been suspended?
Well, I would sure hope not. And there are other judicial forums in which to challenge the lawfulness of the surveillance. And ordinary Article 3 courts may arrive at conclusions that are distinct from the Foreign Intelligence Surveillance Court conclusions, as we saw, for example, in connection with the program that was disclosed by Edward Snowden involving the collection of Americans' call records, the bulk collection of records of virtually every call placed on major American telephone networks. The Second Circuit ruled that that program was not authorized by the statute, and subsequently Congress enacted the USA Freedom Act, which put an end to the program. But ordinary Article 3 courts may not necessarily agree with the Foreign Intelligence Surveillance Court's conclusions, and so the FISC shouldn't have the last word. Unfortunately, again, as I mentioned at the outset, it is very difficult to challenge the secret surveillance in ordinary, open, public Article 3 courts.
Ashley, this is not the first privacy scandal Yahoo has been involved in. And just a few weeks ago, it was revealed that 500 million Yahoo accounts were hacked. What does this say about Yahoo's security policies and about privacy protections more generally when it comes to our activity online?
I think, again, it underscores the need for individual consumers to be very aware about the threats to their private communications, not only from malicious foreign actors, but also from the U.S. government.
Does the U.S. need stronger laws and regulations in order to protect privacy?
Absolutely. In the wake of the Snowden disclosures, we have seen some modest piecemeal reforms. As I mentioned, the USA Freedom Act, which put an end to the bulk collection of Americans' call records, and a separate policy change within the executive branch called Presidential Policy Directive 28, which extended some modest rights, or recognized the interest in a modest way of the privacy interest of non-U.S. persons. But much more significant reform is needed. And in particular, if this surveillance was conducted under Section 702, Congress needs to have more information about how Section 702 is actually being used, and we as a nation need to debate much more robustly and much more openly the legitimacy of this surveillance authority, which is set to expire in December of next year.
And out of curiosity, Ashley, are there any members of Congress who are actively pushing to try to make some of this more transparent, especially the nature of the FISA courts? Because as you mentioned, and as most people know, that all of these requests and grants are being conducted in secret and not being disclosed, and people are not sure whether or not much of this is even legal. So who in Congress is actually working on behalf of privacy experts, on behalf of the American public, to make sure that most of these proceedings are being made more public and more transparent?
Mm-hmm. And I would just note that there has been marginal increases in transparency around the Foreign Intelligence Surveillance Court, but there's still significant obstacles to actually understanding what's going on there. I would say, in terms of Congress people on our side, Senator Ron Wyden has been absolutely invaluable to this fight and continues to push assiduously for greater transparency in the FISA court and also for surveillance reform. While he was in the Senate, Mark Udall as well. And also while he was in the Senate long ago, Russ Feingold. And it appears that Russ Feingold may be joining the legislature again. I'm not sure what his polling numbers look like, but he's also been an advocate. But there's definitely a contingent of legislators. I don't work directly on the policy side, and I as a litigator, I don't lobby, but there are definitely legislators who've been supportive of the civil liberties and privacy communities.
We've been speaking with Ashley Gorski. She is a staff attorney at the ACLU's National Security Project. She works on all these issues related to electronic surveillance, national security, prosecutions, and detentions at Guantanamo. Ashley, we appreciate you joining us today. Thank you.
Thank you.
And thank you for watching the Real News Network.